Yes, good morning. This is the matter of 𝐬𝐮𝐬𝐫𝐞 and others versus the City of Johannesburg and others. Case number 190385 of 2025 and number 5 on this court's urgent court roll, which was in fact concluded this past Friday. Yes, the appearances as before.
Yes, Judge. I don't know whether we have mentioned the names of our juniors.
You have, thank you. Thank you. I have a note of that, and I think my registrar does as well.
As
yes, thank you. Just to place this matter into perspective, and for those parties who are obviously interested, this matter stood down from Friday the 31st of October 2025 until this morning. I will not repeat the remarks or the reasons therefore as placed on record by this court on Friday, but as indicated, this would give this court the opportunity over the weekend to consider inter alia whether this court could mero moto direct that the parties refer the dispute to mediation with appropriate relief. Over the course of the weekend, this court, having decided that it could in fact do so, had prepared an order which it proposed to hand down. What then evolved over the weekend was that both parties also prepared their own draft orders, of which this court had sight this morning. In light thereof, this court met with the legal representatives of the respective parties in chambers to discuss inter alia not only the draft orders, but more importantly the order that this court intended to make. A copy of that order was presented to the parties was presented to the legal representatives of both parties and was discussed. Following thereon, the parties were in agreement thereof with the sole provision of the issue of costs in respect of Part A. So that is the only issue, I understand, which is and remains in dispute between the parties. As indicated in chambers, I intend to hear the parties solely on that issue prior to then making the order as referred to earlier. Yes, Ms. Neyman.
May I please the court, my lord? My lord, my submissions are going to be very brief. Firstly, SERI for the applicants is an NGO. They have been partially successful in these proceedings, and I think on that basis it is fair and equitable to award costs to them, alternatively a portion of the costs, and further alternatively that the costs be reserved to be determined with as part of the Part B of the order. The applicants and the city are not on the same footing in that regard, and litigation such as this should not be discouraged, and NGOs in that regard fulfill an important function. So those are my submissions as the court pleases.
Thank you, Ms. Neyman. Yes, Mr. Machaba.
Thank you, my lord. My lord, the issue of costs generally are dealt with under the following principles. The general rule is that costs are ordinarily awarded to a successful party in order to indemnify him or her for the expense to which he or she has been put through, having been unjustly compelled either to initiate or to defend litigation, as the case may be. In this instance, my lord, we also from the city, contend that we have been partially successful with the draft order that the court intends to hand down. So there is, on that basis, my lord, and your lordship would have seen from our heads of argument that we have not sought costs from the applicants. And it is on that basis that we have also maintained throughout that no cost order at this stage is to be made. In the event that your lordship is minded to do so, we agree that those costs can be reserved for determination in terms of Part B. Otherwise, in relation to Part A, my lord, our instructions remain that there should be no order as to cost, or that each party is to pay its own cost. Largely on the basis that the issue will stand down. The disputes, insofar as it relates between the parties, will stand down to be dealt with in terms of the interim measures that the court has proposed. So on that basis alone, there is no basis upon which the applicants would be entitled to cost order. So we submit, my lord, that the correct and the appropriate order at this stage is that each party to pay its own cost. In the alternative, my lord, that they can then be reserved for determination at a later stage. Those are the submissions that we wish to make, my lord. Thank you.
Thank you. Any replies?
No, my lord.
Thank you. Yes, in the first instance, it is trite that whilst costs should normally follow the result, if that result is clear, unless unusual circumstances exist, it is further trite that ultimately costs fall within the general discretion of this court to be exercised judicially. It is not necessary for this court to, certainly at this stage, and having regard to the circumstances under which this matter has been heard, to provide reasons for the decision this court has reached in respect of costs, and these are costs in respect of Part A of the application, that is the urgent application for interim relief. But the parties can be assured that not only has this court taken into consideration the submissions made by counsel in respect of both the applicants and the respondents, but has also borne the facts of this matter together with the applicable principles in mind when exercising its discretion. In respect thereof, the court finds that it would be just and equitable if the costs in respect of Part A are reserved for determination by the court hearing the review in Part B. That is the decision in respect of costs. Returning, and that will be included in the order which this court will hand down. Returning to the order itself, then it is not necessary in light of the fact that in the first instance the court will really only be granting interim relief at this stage, and further in light, as already mentioned, the fact that other than costs the parties had ultimately come to an agreement as to the nature and form of the order to be granted. But simply wish to say that the order made by this court has been made with the interests of both the applicants and the respondents in mind. It caters as best as possible for the constitutional rights of the applicants to earn a living and the obligations of the respondents, with particular reference to the first respondent, to ensure that the economy of the City of Johannesburg continues to grow, bearing in mind that the rights of other citizens frequenting and living in the Johannesburg CBD also need to be protected. Importantly, in the event of both parties participating fully in the mediation process as catered for in the order, and reaching common ground on issues that have plagued all of the parties affected in this matter since at least 2013, this will bring an end of just over a decade of conflict and uncertainty. However, should this not be the case, the order of this court caters for the finalization of those issues in respect of which the parties are unable to agree. In this regard, the order makes provision for a suitable review application to be instituted by the applicants. If necessary, such a review application would finally put an end to any outstanding issues remaining between the parties, something which, despite regular litigation between the parties, has never been to date proceeded with. Before handing down the order of this court wishes to thank all of the legal representatives and various other parties for their cooperation.
Is the enforcement by the city of its bylaws, of its informal trading policies. The city seeks to ensure a safe, secure, and clean environment for all its inhabitants. The city recognizes the significance of and contribution of the informal trading sector to the economy of Johannesburg. But at the same time, the city insists that it be done in an orderly manner. So the outcome of this hearing today entails exactly that everyone who seeks to be allocated a stand or facilities to trade as an informal trader around the streets of Johannesburg, which includes formal markets that have been demarcated by the city, must do so having followed the processes that the bylaws of the city and its policies require. So that process entails verification. The city must know who you are, where do you reside, what are you going to sell. Are you going to be selling pap and vleis on the streets of the city? If you are going to be doing that, you must comply with the law that requires you to have certificates to handle and manage food that you sell to the public. If you are going to have gas stoves in the pavements, you must do so in a manner that's safe and secure, so you must have appropriate certifications for that. If you are in the country as a foreign national, are you here legally? Because if you are not eligible to be allocated a stand. So this verification process that the city is going to undertake in terms of the court order that has been handed down today will ensure that that order is maintained and those that are eligible are allocated stands, and they will be allocated stands and trading facilities having regard to the facilities that are available within the city. So it's all about finding a balance between anarchy and an orderly allocation and conduct of trading activities around the streets of Johannesburg. There are interested parties here. You've got property owners, you've got tenants, you've got motorists, you've got pedestrians who can walk pavements, and this is all about it. This operation that the city has undertaken, which brought this matter here, is about just that. So it's about a safe, secure, and clean city environment that the City of Johannesburg is trying to achieve.
The order has dates on it from the 4th, and then it must be concluded, I think, by the 19th. So is that the amount of time that the city basically has to finalize everything, permits, allocations, verification?
So the city is not going to be doing anything out of the ordinary. This is the process that every other person who wishes to conduct business as an informal trader in the city has to go through. But sadly, these applicants sought to achieve that, leapfrogging the process, coming here ahead in the hope that they would be leapfrogged ahead of everyone and be allocated stands by court order. So this court order sends every applicant back to the process that the city applies. It is only that these applicants, taking into account that the hardships that they suggest they've been going through, having not traded from around the 5th or so of October, that the city has considered it necessary to expedite that process to the extent possible. But the city does this every day. If you go out to 66 Jordan, there are people queuing today who are not here in court, who are seeking these rights to trade as informal traders around the streets of Johannesburg. And these people will be joining those queues, albeit that in their case, considering the interruption, the city will expedite the process.
So is the city going to allow then for them to go back to de Villiers once they have done the process?
De Villiers is not a street demarcated for informal trading. So there will not be stands allocated at de Villiers Street because the city demarcates markets. To my point earlier, you don't just pick a spot because you like it. The city demarcates markets, it demarcates stalls where informal trading may be conducted. There are also restrictions in terms of, traffic legislation. You can't conduct, a trading activity within 5 meters of an intersection. You can't conduct trading activity in a pavement that's not more than 3 meters wide. There's a host of other limitations that are prescribed in terms of the bylaws of the city. So those are always taken into account when the city decides where to proclaim markets, where to allow trading, where not to allow trading. Congestion. De Villiers had gotten to a point where there was no room for vehicular traffic to move because everyone had just decided to locate themselves there and set themselves as they wished. But unfortunately, there are no demarcated areas for trading in de Villiers Street, so it is not one of the areas where there will be allocations for trading.
Just to maybe be clear, does this allow for every store? So let's say the entire city, where you have to review people who are selling in the street, or is it just de Villiers?
So the operation is ongoing. It starts somewhere. If this court precinct itself has a history, if you go out, it looks different. You see JMPD located around the street corners here. And de Villiers precinct was but one of the precincts where the operation started. It's an ongoing operation, and it's all about ensuring that there is adherence to the bylaws and policies of the city relating to informal trading. So it's an ongoing operation.
So last week there was already a verification process that was underway. The city told us that there were 40 people who had already been verified. Do you know how many have been verified today?
I would not have that detail, but as I said, this is a process that happens every day. As you and I are speaking here, there are people, who are applying to be verified and are being allocated stands as we speak. So it's an ongoing process, and this is the essence of this outcome, that everyone that came here to court to complain they were treated unfairly are directed to follow the process that the city utilizes to allocate stands.
One second question. Does this mean that this thing will be applied across the city, not only in Johannesburg? Just for clarity.
It is indeed so. These processes are happening. If you go to Rabi Ridge, you go to Tembisa, you go to Soweto, everywhere. These processes are happening because the bylaws of the city apply not only in the inner city precinct, they apply everywhere in our neighborhoods. You just don't pick a pavement and trade. You have to go through a process. You can only trade where there are demarcations for informal trading.
Secondly, on the issue of when you conduct the operation of the verification, are you also going to work in the Department of Home Affairs to deal with those illegal immigrants?
So there is the concept of cooperative governance. Organs of state cooperate with each other to achieve their respective mandates. So if there is an operation, naturally, Home Affairs must verify that every applicant that is not a South African does hold a valid visa, valid passport. Customs, to the extent that there is merchandise that requires or involves their scope of work, will also have to come in to, do their work as this operation unfolds. So it's in the nature of cooperative governance. The agents of state work together all the time.
But do you have enough space? Because we saw that the city said something about 200 stalls, and people that are here were saying it's 527 people that are affected. Do you have enough space for these vendors?
There are 500 people. We know as we stand here that some of them are already ineligible for various reasons. So that number, we believe, will come down substantially. But even if ultimately there are 300 stalls, presently, it's a progressive process. The city continues to demarcate, trade, and create trading facilities where it can, because it does recognize the significance of the contribution of informal trading to its economy.
Lastly, how prepared are you if it happens that the city has been tracked to the Human Rights Commission, someone complains, how are you prepared to do such if it happens that you are taken to the Human Rights Commission?
Well, my client is law abiding, so if there is a complaint to the Human Rights Commission, just like they came to court, they must go to the Human Rights Commission to answer to the complaint whenever it is raised.
Thank you.
I'm a property owner. I've observed the court order. So have you...
But we are done.
I'm 𝐵𝐿𝐵𝐿𝐿. I'm a property owner and a resident in and around Joburg Park area. So I've been residing in the city for the last 20 to 25 years. And I have been involved in a whole lot of community projects. So I'm fully aware of this ongoing litigation between SERI and the City of Johannesburg. I do recognize personally the constitutional rights of both parties, the informal trader's right to earn a living and the city's right to regulate that type of an informal setup in terms of open spaces and so forth. But remember, as a citizen, I've got the right to a clean environment and safety to a certain degree. As a property owner, I have observed the court order. I'm going to decide if in future, if their process of mediation does not bear any fruits, if we could come on board as property owners, as amicus curiae, meaning as friends of the courts.
What is your take on what has come out?
It's a fair balance of state of affairs. The informal traders that have been inconvenienced for 15 days or so, the city should not be intimidated and take a step back, because there's a lot of crime, vandalism, vagrants. You've got shacks popping up around Joburg Park. You've got vagrants, you've got drug addicts. There are feces around these spaces. Drainages are blocked on a daily basis. It's just taboo and immoral. So in a nutshell, you'll want to live in a city that is clean. And that area, that precinct of Joburg Park, the Villas, Linear North Street Market, it's a tourist site as well. It's not that far from the Johannesburg Art Gallery. So we can't lose tourists as well due to crime and vagrancy that is taking place in that area.
And as an owner, has it affected your property in any way?
It does. Some time ago, somebody wanted to buy a property. FNB, they came for their assessment. What they do, the banks, is they do an area assessment. They mitigate risk and benefit factors, and they declare the area as a dangerous space. So you can't even sell a property at a value that you would want to. If it's worth 100,000, all that thing devalues the area. So it becomes half the price, 150,000. You will still struggle to get that in any case as a property owner. So it's just a set state of affairs.
Thank you.
As the organization, we are very happy with the outcome. We think that although it wasn't an overwhelming success, but by agreement, we're able to get what the traders were looking for, which is to be regularized. And that is a victory for the traders and the organization, because had it not been for this litigation, we would have found ourselves in a position where traders are forgotten with, as was the city's intention.
In this ruling, is there a winner or loser in this part A of the ruling?
I don't think there's winners or losers, but what has won, or what came out triumphant, is the law. The law does not permit, or did not permit, the city to remove the traders the way in which they did. And now with this order, that is going to be rectified, and it's going to be rectified on an expedited basis. Come the 18th of November, if that is not done, we'll be back in this court to say that the city has failed to comply with the order of this court.
So, judging by the judgment of the 2013 Constitutional Court, is this part of ammunition going forward to Part B or what?
It certainly is. It certainly is. And remember, even these unlawful removals of traders, the Constitutional Court then declared that it was unlawful, and it interdicted the city from continuing to do so. But the city has done so nonetheless, and it is the reason why the judge has said that he is hoping that this order will certainly be go a long way in putting an end to that court case. But certainly, we need to see the 2013 Constitutional Court order to its finality.
What about the threats by the government that among the traders they must also be removed? What's your relation to that?
Well, we have never said that the state is precluded from enforcing its laws. If it's going to enforce the laws in a manner that they're supposed to do so, then that is fine. But threats of just saying that they're not going to regularize informal traders merely because they are not South Africans by origin, that is not going to fly. The informal traders that we represent are here legally. They have passports, they have asylum seekers, and therefore those traders will be regularized, failing which will come back to this court.
Are you able to put your head on the block and say you are aware of everyone that you are representing in this case and that their papers are in with
Certainly. That is why you had the judge referring to lists. We don't represent people in vacuum. We represent people who take instructions from, and we know. So there are lists of those people, and those are the people that are going to be regularized.
What do you say about the perception that SERI has been going against any activity from acting into violence to doing away with people living in high. What do you say about that sentiment?
First of all, in relation to this case, this order by agreement is telling that that is false. Because if that was true, would not have agreed to the city regularizing the informal trader in the way that it has been ordered in this court. Secondly, on the issue of buildings around the inner city, we have clear laws in these countries which needs to be followed. That paramount in that is the Constitution of the Republic of South Africa. Section 26.3 of it, which states that no one may have their homes demolished or be evicted from their homes without an order of court being made after taking into account the occupier's circumstances. It further goes on to say that no law may permit arbitrary eviction. What the city has been doing is promoting arbitrary eviction, is removing people unlawfully without court orders, and that will not be accepted in this constitutional democracy. And SERI, as a legal NGO, will continue to fight against such unlawfulness.
But when those buildings collapse or burn down, is the city that the government, I should say, that takes the blame?
As well they should, because it is their responsibility to make sure that those buildings are maintained. Those buildings are provided with basic services. You will know that not so long ago, a commission that sat headed by the retired judge, Judge 𝐼𝐶𝐬𝐿, found that in fact the city broke its constitutional duties by failing to make sure that the buildings are maintained, the buildings are provided with services, and that everyone who lives in those buildings is properly catered for. So it is fitting for then the city to take the blame when something like 𝐬𝐮𝐬𝐫𝐿 happened, when the building collapsed, because they are failing in their obligations.
Thank you.
Where's Nabila?
She's outside.
I'm